Welcome back to part 2 of litigation defense for risk managers. In part 1, we spoke about the importance of documentation. Our sponsor, SafeQual, has software to help you do just that with excellence. For more information, go to our sponsor's website at www.safequal.net, click on Key Functions, and scroll down to the Claims Management section on their Key Functions page. Now, let's get started on part 2 with Leanne and Scott. Hey, can I interject a question? Do plaintiffs take their cases into the court of public opinion, and what do risk managers need to know about when that happens?
Yeah, it depends on the case. They certainly, it's what plaintiffs do. They try to make the case about everything except for, the facts itself and the practice of real medicine. When you start seeing, if you're talking about situations where, the plaintiffs are actually, the counsel is going and talking to the media, then, that's, that's a clear issue that needs to be addressed from the top down. A big part, at least from my perspective, to the extent I get into risk management, is that it's all about controlling the flow of information and making sure that only the appropriate people are the ones who are commenting on behalf of the organization. So, typically, there's somebody that's designated at the hospital that decides when and how to respond to that. There's a committee that gets involved that, decides what the message might be. And then one person is responsible for conveying that, to the extent where, a hospital isn't involved, that, we're just talking about cases where I just defend a doctor and they're getting involved. The plaintiffs are speaking to the media. I always make sure that, all witnesses that are under our control, tell them, are instructed to say, we don't, I have counsel in this matter. I'm not going to comment. Please contact my lawyer, and they give me their information, and then we decide on our end how to handle that. But there are, to the extent then this bleeds into trial, then we start in pretrial motions. We do everything we can to keep that whole public opinion out. And, if the judge lets some of it in, then we're preserving everything for appeal, because that type of outside pressure, while it's inevitable in some high profile situations, I think it is a case that we can, develop reversible error and get the appellate team involved just in case something bad does happen and there is a big verdict.
And that's one thing that I would like to comment on is the social media aspect. And with the ease of getting on social media, a lot of patients or their family members might go to Facebook or Instagram or whatever and post pictures or comment, or it might be an employee that's really upset saying, we were short staffed tonight and I'm just, I'm tired, these errors are occurring, blah, 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 blah. I've had multiple situations like that. So I think it's also the institution needs to have a social media policy and educate the staff that they do not have carte blanche, authority to just go out and post things on social media, because those things will be found. Yeah. I guarantee you, and the doctors need to be educated as well. I mean, I've had cases where somebody has posted a picture online, and even though they didn't use the name of whoever the patient was, it was a small venue, and it would have been easy to figure out who was, networking throughout the community, who was sick, who was not. So we have to be careful about that. And my experience has been, risk managers need to be familiar with the C-suite to figure out, if there is news media that are, you have a reporter call in the hospital or whatever, who needs to respond to that? Who has the authority to respond, and make sure that it's a thoughtful response. And as Scott said, you might want to consult your legal counsel, because I know I had a case in which we advised a CEO not to respond to a news article. And the reporter called and wanted a response to plaintiff's article, and she was advised not to respond, but she responded anyway. And then the demand went up significantly on a case that was in the middle of litigation. So folks need to be careful about that and sensitive to that, and circle back with legal counsel, because at the end of the day, guess who's going to get that problem? People like Scott or whoever you have defending your cases are going to be sitting trying to figure out how are we going to work our way out of that scenario where there might have been some admissions, there might have been some damning information that innocently was communicated, but it was spun the other direction by plaintiff counsel.
Yeah, to defend a successful case, I mean, we need to have as much of the factors under control as we can. And if, people start talking to the media or posting things on social media, we lose that control, the defendants lose that control, and then plaintiffs just have a field day with it. The value of cases do go up substantially when people start talking, even if they think that they're helping or that they're defending the company. It almost always backfires. And so we really do need to control the flow of information. It's just critical to lawsuits.
We didn't talk a whole lot about when we go to trial and what you want to see. Because a lot of times people settle on the courthouse steps, and they get to the point where, they get weak-kneed right before trial starts. And so, Scott, how are you, what do you want to see, in cases where we've thought about it a lot and we have a case that we want to take completely through trial?
Well, the process begins quite a while beforehand. I'll just take you through what we do. I'll sit down with my team, whether that's, usually these medical malpractice cases are big cases. So I'll at least have a second chair, nurse paralegals involved, legal assistants involved. So we sit down about, 60 to 90 days beforehand and create a checklist of who does what and by when. And part of that is also getting, the doctor or hospital risk management involved. We need to go through and we need to figure out what, how our case is going to be presented. And that entails, what the pretrial motions are to sort of figure out what evidence is going to be presented and how, exhibits, demonstrative exhibits. Sometimes we need, maybe it could be as simple as we need one of those model spines from the hospital to use as a demonstrative exhibit. We'll need to meet and prep with the witnesses. It's always a good idea to get the risk manager or hospital personnel or nursing supervisors involved with that. There's a lot of scheduling of witnesses. We issue trial subpoenas. We need to set up evidence depositions. We work through jury instructions. And sometimes the hospital has had this case tried before, and sometimes we often, we have brief banks and we've got past motions and exhibits and things we've used, but sometimes the hospital does too. And so if the risk manager has some of these types of things, that can be helpful for us. We often have several meetings with the doctors, with the experts. We need to put together reports to the insurance company. But we're prepared at any moment to for the case to settle. But we are going ahead as if 60 to 90 days before trial. We need to start moving ahead as if this case is going to be tried. Because the last thing that you want to happen is to be stuck, to be unprepared. And I've come in as appellate monitoring counsel in cases where they were certain that a case was going to settle. And so they didn't begin preparing the case until 2 weeks beforehand. So I guess, long response short, having the decision made as soon as, you can, that we're going ahead with this is helpful. And of course, we talked about there's value at every point along the way. So, that's not to say that at some point, we're going to start talking settlement. I mean, there's settlement considerations, every witness, every day at trial, but, giving defense counsel the go ahead, hey, move full steam ahead, that needs to be done well before, a couple weeks before trial.
Now, the role of the risk manager, you may participate in the decision-making on which cases go to trial, but with the caveat, you need to know your case and the strengths of the case and the weaknesses of the case. So when you're asked to present to a committee, and certainly on the inside, you're probably going to have a chief legal officer, counsel that you talk with internally about choosing this case to go to trial. The other thing is risk managers, if you haven't participated or you don't know, you might have a mock trial if it's a big exposure case, or you might participate in that, or, real trial. I've always been asked to go in and to report back daily. And I also, as a safety net, have my counsel report daily. So they not only get my feedback as the risk manager or maybe the adjuster, but they also get counsel's feedback. But counsel usually sends their report to the risk manager. We compile the information and send it out to the executive team on a daily basis. That way, things ebb and flow. And so if the C-suite and chief legal counsel does not feel like things are going in our favor, then we always have the choice to settle the case. Now, sometimes you may enter into a high-low agreement with plan of counsel and just proceed through trial. Or you might, people sometimes get reasonable. For instance, if maybe somebody takes the witness stand and doesn't do as well as you thought they would. But every time I've been through trial, I have so much respect for trial lawyers because it makes me my heart just stops. And then I was like, oh my gosh, we're losing. And then you feel like you're winning and things are going good, bad, and the ugly. And I was like, oh, it's just nerve wracking because at the end of the day, I have had cases that we've won that we should have lost. And I've had cases that we've lost that I thought we should have won. And I've had cases where we have appealed certain things. So I think it's important if you're a risk manager and first starting out, try to pair up with counsel to maybe go see some mock trials or go monitor them, in the courtroom setting. I used to do that. Whoever was on my panel list, I make it a point to go see them in trial and see them as they interact with juries and what their styles are, because I think that is helpful. Because ultimately you're going to be asked, well, how did your lawyer do? And Scott, for the audience, some people may not know what it means for someone to second chair. So if you could kind of explain what the roles of a second chair would do versus your lead counsel, what do you do that's different than what they do?
Yeah, so when you think of the trial lawyer, that's what we call the first chair. That's the one who is going to do the voir dire, most of the voir dire. Sometimes the second chair gets involved, but the one who is going to give the opening statements to the court, the one who is going to examine or cross-examine key witnesses. That's the one who is running the show. An effective second chair, a good second chair is a key to prevailing in a good trial. You need somebody who's going to do a lot of the grunt work because there is a lot to do, a lot to do before trial and a lot to do during trial. I mentioned some of those, the pre-trial motions, and making sure that the medical record is ready and getting everything set up. The second chair typically prepares most of the pretrial motions and actually does some of the drafting and the jury instructions. The first chair obviously gets involved on that too, but the second chair then will question some of the, say family members, some damages witnesses, maybe if it's an expert directed at another party or another doctor, who doesn't really touch upon you, then that second chair will get involved and be the one who takes the lead. And if any cross-examination or cleanup needs to be done after, the primary attorney questioning has been done, that person's going to come in and ask those questions. You will also use your second chair, will be when you're reading and preparing for trial and reading your openings and your closings. They will sit there and listen and critique and help you develop all of your arguments. So, it really takes, it takes two lawyers and it takes a team to try a case.
So what about, oftentimes you might, or me as a risk manager might be asked, so are there any appealable points? And so when you're sitting there, like, watching the trial happen and live happening and, a lot of actions going on, people are taking the stand, they're getting off, they might take the stand for several days, depending on the type of case. Can you talk to the risk managers on what they should look for or what kind of dialogue they should be having with their counsel about what's appealable, what's not?
Yeah, sure. A lot of times insurance companies will get appellate trial monitoring counsel involved, and the scope of the assignment sort of varies depending on the trial itself and how complex it is. But a lot of the times you start thinking about those appellate issues way before you set foot in court the first day. The pretrial motions, you will want to see the pretrial motions, because again, that's sort of developing the rules for how this trial is going to go ahead, who can testify, what evidence can come in, and that's the first step in what the attorneys do, and that's preserving objections and preserving the record for appeal. So they will argue the motions, and then you need to make sure that you have skilled counsel involved that is making sure to continue to preserve those issues, because there are certainly points in the trial where, okay, you might have got a favorable ruling on a pretrial motion saying, okay, this evidence isn't coming in, but then, the plaintiff's attorney, whether purposely or unintentionally, asks some questions that he or she is not supposed to, or introduces this evidence. And, you have to make sure that you are continuing to object, to make sure that you are not waiving the issue, because if you've waived the issue, then, a lot of times there is nothing that you can do on appeal. So as a risk manager, you're listening, you're reading the pretrial motions, you're hearing those rulings, you're seeing what counsel, gave you as far as a summary of those various rulings, and then making sure, listen up during the trial to make sure that that evidence is staying out and that counsel is continuing to preserve those objections. And there's other little things that need to be done along the way, making, if something, if it seems like there's been some irreparable harm, then the counsel is going to move for mistrial, and they're almost always denied, but then the issue is preserved for appeal. So it's all about preservation.
And if I didn't say so earlier, I will now. It's important for the risk manager, the C-suite, which includes your chief legal counsel, or you might have an outside counsel that's acting as general counsel. It's important for you to align those folks along with who your trial counsel is going to be to strategize and plan and talk about the case prior to everything starting. Because once the trial starts, you're going to be so busy. The lead lawyer is going to be so busy that you don't want to interrupt their focus and stuff. And so it's good to have a game plan going, kind of like sketch it out and talk about those things prior to. That way, then when things start, you can rest assured things are flowing. And if there's a deviation, or if maybe, Scott, I know this happens, something happens that is unexpected during trial. Maybe somebody doesn't show up that you counted on being a witness and taking the stand. That was maybe your star performer. Maybe if that person doesn't show up, it changes the complexion of the case. And you might recommend we sell the case then if we don't have that person, or it might be something totally different, or that could happen to the plaintiff lawyer and his team. So just keep in mind that anything's possible during trial. I've seen it all. I had one where the plaintiff attorney passed out. I was like, I thought we were going to have to call 911, and he ended up saying that his blood sugar was low and a whole bunch of stuff, but it was just theatrics. And I've never since then seen anything like it, but just expect anything.
Oh yeah, and I've got I've got tons of stories like that. One of our trials that we ended up prevailing in that trial. It was in the middle of my client's testimony on the stand, and he's an internist, and somebody in the back of the room, just in the benches and the galley in the back, you could see that person slid down in their chair and clearly collapsed. And he can't, just keep running off the box out of the witness box, and came and attended to him. And the whoever it was, the person who had passed out ended up being fine. But then, the trial then just went ahead. And so we had the advantage of the jury just saw our doctor go without thinking, go and try to save somebody's life. And that's another story in preservation. That's something that, if that were the plaintiff's expert that had done that, then, we would have gone in and moved for mistrial. We were shocked that the plaintiff's attorney didn't even make a motion for mistrial. So, that's the story, a lesson in anything can happen. And you need to make sure that, counsel is not distracted by anything that happens, and makes the appropriate objections too.
Yeah, and I think too, from the risk management lens, it's so critical that you get the experience from cradle to grave, and you get to walk through that at least a couple times. Maybe you don't have time to see a lot of trials in the beginning, but I would put it on your to-do list, because it's the experience that you get from that is amazing, and it helps you when you evaluate things going forward, because the ultimate outcome if you go down this path versus the early resolution path. So whatever you do and how you have your operation set up, keep that in mind.
And to that end too, be there for the verdict, hear the verdict read, and hear the judge discharge the jurors. And in some states, or even some judges, a lot of times it depends on the judge, will permit the jurors, if they so desire, to go after trial and talk with the attorneys. We're instructed to basically just sit there, and if they want to come up to us and talk with us, then talk to them. But there's a lot that you can learn from hearing what they have to say, and they focus in on some things that you don't even think were a factor in the case. And that was the key factor that they talked about for an hour in the room when they deliberated the case after the evidence. So, being there for the end and seeing if you can actually, hear counsel talking with the jurors about what happened, I think is invaluable.
Yeah, that's important. Thank you for all that good information, Scott. Risk managers need to take that to heart and consider that as they, look at their risk management programs. And when they start to train, like for me, I would always have my teams go out and evaluate counsel and sit through a trial and come back, and we talk about it. We talk about whatever questions, we bring counsel back in so they could ask counsel. And so it was a great learning opportunity.
I once had the opportunity to speak with a judge after a case I was attending that I wasn't a party to. The case had settled early, and the judge didn't have anything to do that afternoon. I was surprised that they were willing to talk for a half hour or so off the record. Mm-hmm. Is that something that you also encounter?
Yeah, well, I think for me, I have never run into a situation where, if the judge or the lawyers felt there was some learning opportunity and want to help somebody understand the process, I've never been told no. But at the same time, once you sit through trial, you're tired of sitting, and people are like running out of there, right? Get back to them. But Scott, you can like comment about the judges and stuff, but I've never had anybody be adamant saying, no, we're not talking to you. They've been
No, and it depends. If we're talking about a case that's settled, then sometimes the judges will sort of talk to you in confidence. I mean, sometimes they're curious. They had been living the case for a certain period of time, and so they wanted to know. And you do develop a rapport with some of the judges, especially after a several week trial with them, and especially after you see them a couple of times. Then and you see them in functions outside of various legal dinners, happy hours, those sorts of things. I mean, we do come across them, and so they do like to talk. But if it's a case that just went to verdict, I mean, they're concerned. I think they don't want to create an issue by talking before the post-trial motions and before all the appeals have been exhausted, because sometimes something that they say can backfire and can all of a sudden become part of the appeal.
Right. Yeah, they want to make sure there's fair and due process. I mean, for instance, when you think about, is a trial fair, and is the person on trial or the organization on trial going to get a fair trial? Look at the George Floyd matter. Like when there's a case that is like national news, whether it's an organization, a person, whether it's criminal or non-criminal, that is something to consider. Like, where do you go if you're in a small venue, and how do you ensure there's going to be fair and due process?
Yeah, it's always tough. I mean, you see in these smaller venues that sometimes it's tough not to get somebody on the jury who, the jury pool is only so big. Sometimes you are stuck with somebody who is, second cousins with the guy that works with, the plaintiff, and there are those relationships there. We've seen it. I wasn't a part of this one, but a partner of mine told a story way down in Southern Illinois on a toxic exposure case. They were in the middle of picking a jury, and the juror pool is out there, and they're in full mode, and all of a sudden somebody gets a phone call, and they find out that this case was part of many cases that had that across the country on this toxic exposure case that had settled, and so in the middle of voir dire, they tell the judge, Judge, I'm sorry, but we're done. This case settled. We can send everybody home. And somebody on the jury said, their case settled. So Johnny's getting his money, and all of a sudden the whole jury pool starts clapping, and everyone starts cheering for the plaintiff because he got a settlement. So thank heavens that case settled, or I mean, who knows what would have happened.
Now, Scott, can you talk briefly for like a minute or so, people that haven't been to trial, you typically, federal trial is different than, a civil trial with 12 jurors versus 6 jurors in a federal case. Can you explain like how it works? You've got the foreman who's going to be the spokesperson and who normally reads the verdict. Can you walk through briefly what that looks like for the risk manager who hasn't had that experience?
Yeah, typically, I mean, with and sometimes it does vary state by state, but for Illinois, we typically have 12 jurors, and they usually have 2 alternates. Sometimes they'll have more alternates just in case. And so they're sitting in the box. Well, these days I was a part of a trial where they had to honor the social distancing. So actually everyone had to sit in the gallery 6 feet apart from each other. So, they're sitting there taking all the evidence. They're not supposed to talk to each other during that entire time. We as counsel and, for risk managers and appellate counsel, we're constantly looking at the jury, trying to evaluate, who is going to be the foreman, because, we don't necessarily know until it happens. We're trying to decide, who's going to be the leader, who's the one who's going to be doing the talking, who's the one that's going to be doing the listening when they, go back and discuss the case. So they're instructed to, and they're supposed to hear all the evidence before they start talking. Even, during the breaks, they're not supposed to talk to each other throughout the entire trial about, any of the evidence. They're supposed to wait till the end. And then at the end of the last after the last closing and the judge reads the instructions, then they're discharged to go in the room, the jury room, and basically talk until they can reach a verdict. And, it depends on the circumstances. Sometimes they can send questions to the judge or to counsel to be asked, but, at some point, they'll say that they've reached a verdict and, they're walked out. And whether it's the, 6-person or the 12-person, I mean, they will, they enter the room, you hear the verdict being read. Typically the judge, is handed the verdict form, and, he asks the foreman, is this your verdict? And he says, yes, reads the verdict form. And then sometimes, after they give the verdict, the jury, will be asked, each one of the jurors will be asked, was that then, and is this now your verdict? And I've never had a situation where somebody has said no. I've seen somebody pause, but I've always, they've always said a yes. And so at that point, then they're sent back to the room and discharged. So yes, it's different in different circumstances. Different states have an X number of jurors, and they're handled a little bit differently. But at the end of the day, there's a foreman and the rest of the jury. They go back, they talk about the verdict, they reach it, and you're left with it, whatever it is.
And sometimes post-verdict, things can be negotiated. If there's a large verdict, maybe it's beyond policy limits or whatever. I know I've had cases where, there might be, and maybe you can briefly talk about this. It seems like there's always opportunity for like negotiations. So as long as the plaintiff attorney is willing to negotiate still post-verdict, if they get their money quicker or there might be certain benefits. Talk about that a little bit.
Yeah, certainly. I mostly have defense verdicts to my belt. I love being able to say that, but we did have a trial on damages in a case a long time ago where we got hit pretty hard. It was like a $30-something million verdict, and probably well deserved based on the facts and circumstances of the case. But over the course of a 3-week trial, we talked about how there's all different kinds of potential for appeal, and there's potential reversible error. And so that's the negotiations then can begin after that point. I said, okay, you're left with the verdict, but that doesn't mean that you have to pay it at that point. There is as soon as the verdict is, as soon as the verdict is read and it's reached and the order's entered on the verdict, post-judgment interest in almost every state starts to run. But there's always considerations of appeals. And so the plaintiff's lawyers know, it could be, appeals could take years. And then, after appealing to the appellate court, it can go to the Supreme Court. And so, you can use those opportunities to negotiate down a verdict pretty substantially. And, on top of that, you mentioned there's circumstances where, okay, maybe there's $1 million of insurance coverage, but a $10 million verdict. And so, the plaintiffs want insurance monies for the most part. They don't want to have to try to collect assets of a facility or of a doctor. And so, you do still have an opportunity to negotiate down at that point. You just have to know that that the post-judgment interest, which you are on the hook for, continues to run, but, many, many cases end up being negotiated down as part of the post-trial motions or the appellate phase.
And also there might be caps that are in play that the jurors don't know. So the judge could reduce it down to the cap.
Oh yeah, certainly. I mean, there's always, in post-trial motions, you'll make motions for remittitor to try to reduce damages. And, there are, Wisconsin has a $750,000 cap on non-economic damages that was upheld. And I guess I got to say, it's currently still sitting through what's today, July 27th of 2021, because that, it's a lot of times that the damages caps are constantly being they're constantly being challenged, and so 3 years from now it might be a different cap, or there might not be one at all. But those are all considerations, post verdict.
What are the best arguments for going back to the plaintiff and saying, this is all the insurance we have? Can we meet you at that number?
Yeah, and that typically works. I think that's usually the best argument. And the second best argument is we've got all of these appellate, potential errors, and whether we're right or not, it's going to be a long time before you potentially collect this money.
Mm-hmm.
Well, thank you, Scott, for participating in today's conversation. I look forward to working with you again, and I'm sure we'll talk soon.
Thank you very much. This has been fun. I've really enjoyed talking with these topics, and I'm always here. Please don't hesitate to come back.
Oh, we just finished recording this, and I was talking to Leanne and Scott, and they wanted to offer to be available if you had any questions after this segment. So each of them now are going to say what's the best way to reach them. Leanne?
Yeah, certainly. Please reach out if you have any risk management questions or anything that I could answer from our presentation or in our discussion today. You can reach me on LinkedIn or on Twitter. I'm under Queen of Risk. So I'm happy to participate and be that sounding board. If you're a risk manager and you have questions or you need a network, I'm happy to be available. Thank you.
Very generous. Scott?
And certainly from a defense lawyer perspective, if you have any questions for me, please feel free to reach out to me on LinkedIn, and I think my email will also be contained there too. So either way is a good way to contact me.
All right. Have a good day.
You too.
Thank you.
As you heard from Leanne and Scott, documenting your case is very important. Let me say our sponsor, SafeQual, has reinvented what software should do to make you and your healthcare system more productive with software that enables risk, quality, patient safety, and compliance departments to work better together and with more automation. Their focus on quality management is second to none, and they support this channel. So go visit them at www.safequal.net. Hey, thanks for listening. If you want more, be sure to click like or subscribe. If you'd like to appear on our program, be sure to fill out the SurveyMonkey below. Most important though, if you know someone who should hear this video, please forward it to them so that together we can all work to make healthcare just a little bit less risky.